Welcome to a podcast presented by Knockamson PC. In this podcast, Natalie Klyashtorny will explain the necessity of obtaining legal representation prior to signing a non-competition agreement or restrictive covenant as part of an employment agreement or contract.
When beginning a new job, an employer will often request that a potential new employee sign either an employment agreement or employment contract. Oftentimes, the employment agreement or contract will contain a non-competition agreement or restrictive covenant, restricting the employee's future employment. The reasons why an employer would include a non-competition agreement or restrictive covenant is to protect its intellectual property, trade secrets, confidential information, and client lists, and to restrict future competition. As these documents are potentially legally binding contracts and could severely impact an employee's future job opportunities, it is extremely important that prior to signing any such document, the employee obtain legal advice and have any documents reviewed by an attorney. Most non-competition agreements or restrictive covenants contain time and geography restrictions, non-solicitation provisions, and confidentiality provisions. The restrictive covenant must be reasonable in scope to protect the legitimate interests of the employer from unfair competition, as well as protect an employee's ability to earn a living. Pennsylvania courts employ a three-part enforceability test. The non-competition agreement or restrictive covenant must be ancillary to the employment relationship, limited in time and geographic scope, and necessary to protect a legitimate business interest of the employer without imposing an undue hardship on the employee. A restrictive covenant or agreement not to compete might be held invalid if it fails to protect an employer's legitimate business interest, inflicts an unreasonable burden on the employee, or interferes with public policy against such an agreement. Frequently, courts will find that an agreement is overly broad with respect to its scope in terms of temporal duration or geographic area. If a court finds a restrictive covenant to be overly broad, courts will sometimes modify the agreements as opposed to striking them down altogether. For example, if a court finds that a time duration of 2 years is unreasonable, it may modify the duration to 1 year instead. On the reasonableness of duration, courts will also look at how long it would take to replace the employee and train a new employee. The goodwill of the employer and client relationships are considered protectable business interests. Contacts with clients that did not substantiate a relationship, however, do not rise to the level of a protectable business interest, and courts will only enjoin employees from soliciting customers with whom they personally established relationships. Although Pennsylvania courts have recognized an employer's legitimate interest in trade secrets and customer goodwill, those interests do not extend to cases where the former employee had little to no contact with clients or customers. A restrictive covenant will not be enforced when there is no goodwill between a former employee and a customer. For instance, when an employee is terminated for poor performance, courts will consider that as evidence of lack of goodwill between that employee and the customer, and will not enforce the restrictive covenant. Likewise, trade secrets must actually be confidential to be protected, and in determining the confidentiality of client lists, courts will also look at to what extent the client lists are public. Client identities that are generally known in the industry are not protected as trade secrets. The courts will not enforce an agreement unless actual harm has occurred or is reasonably certain to occur. For instance, if an employee leaves to work for another company which is not in direct competition with the employer, the court will not uphold the non-competition agreement. Non-competition agreements that involve physicians are also scrutinized as to the harm to the public welfare, with access to medical treatment being an overriding concern. When harm is immediate, an employer may also request a preliminary injunction to force the employee to comply with the non-competition agreement immediately, pending the final outcome of the litigation. If a court ultimately finds that the employee has violated the non-competition agreement or restrictive covenant, not only will the employee's ability to work in his chosen field be adversely affected, but he or she might also be liable to the former employer for money damages.
Thank you for listening to our podcast. Nockamson PC is a law firm representing individuals, businesses, and professionals throughout Pennsylvania and New Jersey. For more information about Nockamson PC, please visit our website at www.nockamson.com or call 215-399-1346 to schedule an appointment to meet with one of our attorneys. This podcast is a publication of Nockamson PC and is intended for general information only. It should not be construed as legal advice with respect to any particular situation, and listeners should not act upon information contained in this podcast without first consulting an attorney.